Lawyers can now use AI for certain tasks, but there is a catch. In a big development, the Supreme Court of India has published draft regulations for the use of AI or artificial intelligence as an assistive tool in judicial processes. These regulations also let lawyers prepare or submit documents, pleadings, or evidence in court with the use of AI. However, there is one small catch. If any AI tool has been used to prepare content, it must be disclosed to the court at the time of submission, either through a duly executed declaration or a certificate in the prescribed format. Hello and welcome to The Print. This is Khadija Khan from New Delhi, and I'm going to break down how lawyers and courts will be able to use AI subject to human review under the new proposed regulations. While lawyers can use AI for legal research or drafting, court administration can also use it for the purpose of preparing cause lists or issuing notices. Judges, however, will not be able to use it for any adjudication purpose. Transcription of court proceedings, translation of judgments, orders, and other legal documents, and legal research have also been termed as permissible uses of AI, subject to mandatory review, of course. Administrative functions like case filing, record management, and judicial resource allocation can also be done using AI, the draft specifies. It adds that conversational AI assistants and guided chatbots can also assist litigants and other stakeholders in accessing court services. Although this draft regulation has been released and is still subject to approval, it will be applicable to the Supreme Court, High Court, and all other courts, including tribunals and statutory commissions. Under these regulations, courts are required to set up AI committees, which will oversee, regulate, and facilitate the responsible adoption and governance of AI within its jurisdiction. The regulations also state that accessibility services, including text to speech and speech to text, braille translation, and visual assistance tools for persons with disabilities or language barriers, can also employ AI. As for verification of documents and fraud detection in administrative processes, this also can be done using AI, subject to human intervention, the regulation specifies. Another important caveat is that the use of AI in court processes will be strictly subservient to human judgment and judicial authority. The reason for this is that AI systems function solely in an assistive capacity and cannot supplant or compromise the independent exercise of judicial authority. More importantly, the regulations flag certain uses of AI as strictly prohibited in all court processes. So let us take a look at what AI use is prohibited. No personal data of any person can be used to train, test, or refine any AI system without prior approval, the Supreme Court has said. Also, no judgment, order, or finding of fact or law shall be reached through algorithmic decision making alone or solely on the basis of AI generated information, data, or analysis. Human judicial authority ultimately is the main driving factor in all adjudicatory decisions, these regulations clarify. Importantly, no AI system shall perform the function of adjudication or sentencing in any manner without a mandatory human in the loop, and outputs of such AI systems will be treated as advisory only. The regulations also say that no AI generated output can be submitted to a court as an independent source of evidence without full and transparent disclosure of its AI generated character. These draft regulations specify that every AI system used in court processes must meet high standards of transparency and explainability. Courts must also ensure that when AI tools significantly assist any aspect of the case, the parties must be informed in a timely and accessible manner. The regulations also specify that AI cannot be used for surveillance or continuous monitoring of judicial officers, advocates, litigants, or anyone else within the court premises. Every violation of these prohibitions must be reported to the AI Secretariat, which will then place it before the AI committee. After due inquiry, the committee will direct remedial measures such as suspending relevant AI systems. These draft regulations are open to feedback from the public. However, the deadline is June 20th this year. If it's not too late, your suggestion too could be taken into consideration. And that's all for today. For more legal updates, stay tuned to The Print.